All right, so I'm going to get started here. So good morning. Thank you for joining me. My name is Victoria. I am one of the estate planning attorneys with the Kopenbarger Law Firm. We have been around for over 40 years. Actually, this is our 44th year. So we have been here doing this for quite a while. And one of the biggest things that we want to make sure is that everyone has an understanding of what estate planning is and why it's so important to every single person over the age of 18. So to jump on in, I want to introduce you, if you don't already know us, to our firm. So first and foremost, we are actually one of the largest estate planning law firms in California. And that is because we have such a large team of attorneys, but we also have a very large staff, which you'll see in just a second. What this screen, though, is also showing you is that we have numerous departments. What that means is that, yes, we do focus on estate planning and making sure people are protected, that their families are protected, and that their legacies are protected. But we also have other departments to ensure that those other areas of need can also be met. That includes business and tax. So what that means is if you have a business, if you have tax concerns, if you have additional advanced planning needs, we can still meet those needs in-house. But we also have an estate administration department. That department is there so that after somebody passes away, the family or who's ever in charge of finishing up someone's estate can turn back to us and we can assist them through that process. It's often a very lengthy and can be a confusing process. And so we're often able to shorten the time and add a lot of clarity and peace of mind for whoever is in that role. Then, as I mentioned, we have a pretty significant staff. And the reason that we are able to do as much as we are, and that frankly, we've been around as long as we are, is because this staff allows us to make sure our clients' needs are met in a very timely manner, and that we're able to then again, help you in the different areas that you might need. Then with that, we also have quite a few offices. So if you are in one of our locations, we are absolutely happy and excited to get to meet you in person. But we do also have Zoom capability. And so if you're not able to come in person or these are not in your location, we can do pretty much everything necessary on Zoom at this point. So as I mentioned at the very, very beginning, if you have any questions throughout this, please feel free to throw them in the Q&A or chat options. That way we can try to get those answered. This is going to have a fair amount of information in a relatively short amount of time. So this is recorded. And so if you want a recording afterwards, just let us know. We'll also be posting this on our YouTube channel when it's all said and done. But also I do recommend, again, taking advantage of the free consultation that watching this provides. That way we can answer your more specific questions and make sure that your needs are being appropriately met. So today we're going to focus more on people who may be in the newlywed phase, or you've been married for a while, but you never touched your estate planning after getting married. That's actually a lot of times the bigger demographic that I talk to after this sort of a webinar, is you might have been married for a while and you just never thought about estate planning as one of those steps that needs to be taken after you get married. So how do we make sure that if you are either a newlywed or you've been married for a while, that your estate planning needs really have been properly met? So after you get married, there are quite a few positives, obviously, that come out of that. You're married, it's great, it's new. But if you are a newlywed, just be aware there are then some additional tasks that need to be taken, or I should say steps. One of the big things is making sure that you do have an estate plan that properly covers you, your new spouse, and if you have a blended family or are bringing children in, that they are going to be appropriately covered as well. Depending on when you got married, there can also be significant assets that we need to take into consideration to make sure that things are clear, concise, and follow what each of you really want to make sure happens. But getting married from an estate planning standpoint brings a lot of great opportunities, including tax benefits and asset benefits. So from that standpoint, we definitely want to focus on making sure you maximize the opportunities available. But there's also some hurdles to come after you get married. One of the big things, especially for younger newlyweds, is that they think, well, we're just starting out. We don't even own a home. Why do we have to do estate planning? This is not something that applies to us. But as I'll explain in just a minute, that is absolutely not true. Whether you're married or not, if you are over 18, you need some kind of estate planning. The other issue we see is a lot of people don't want to think about their new spouse passing away or their child passing or them passing and not being there for their child. And so a lot of people kick the can down the road, so to speak. And then there's a lot of other components that go into your estate planning, and it can at times be hard to make decisions on who would it take over if you couldn't, or where things will go if you're no longer here. But because, as I mentioned, we have been around for now 44 years, we have seen so many different scenarios and are able to brainstorm with you and give you suggestions and ideas of how to answer these questions so that you don't feel like you can't do estate planning because you don't know where to start. A few of the other hurdles, just to go over quickly, is if you already had your own estate planning, one of the things that you want to then consider is, am I going to update my current plan to include my new spouse? Now, the reason I say that this is a question, not a requirement, is you don't have to include your spouse, especially if you have assets that you want to keep separate or things are going to stay relatively divided on that front. But for a lot of people, they do want their spouse included in some form or fashion. And so these are all things to really take into consideration. And again, this is where we can help walk you through the pros and cons of all of those options you have. Now, I'm going to jump into some of the essential documents. So if you already have these documents, what you will want to be thinking about is, should I update them to include my spouse? And if you don't have these documents already, now this is going to cover two things. One, how do you and your spouse want to interact with each other, and what role are you each going to play for the other? But also making sure that you understand why you need these in place, at least some of them. When we are talking about estate planning, we are talking about this as a very large topic. This is not just you need a healthcare or a trust. If you talk to any attorney and they are only talking to you about one of these documents, they're not doing an adequate job to make sure that you are going to be fully protected, because each of the things you see on the screen have a different component of protection for you. First and foremost, your healthcare directive is going to be one of the most vitally important documents to make sure that you have in place. This is something that every person over the age of 18 needs, because as soon as you turned 18, nobody had an automatic right to make medical decisions or even have the doctor tell them what room of the hospital you are in. What that means is if you cannot verbally tell the doctor who has permission to act on your behalf, it has to be in writing. Otherwise, again, nobody will have that right. Now, especially if you have been a client of ours, this is something that you likely already have. But if you have either children that don't have this, or you have again gotten married and you haven't updated it, do be aware that your spouse at that point cannot make those decisions unless you've given, again, verbal or written permission. So this is one that very often after someone is married, if they already have it in place, they're going to then include their spouse as their now primary representative. But that is not always a given. One of my very good friends, after she got married, I talked to her about updating her plan and did she want her husband now to be included in this document? She actually said no. And I questioned her and said, okay, well, why? You don't generally hear that a brand new first-time marriage person saying no, they don't want their spouse in this role. Her reasoning, which I think is very valid, is her husband essentially passes out if he has to go into the hospital, whether for himself or someone else. He does not handle medical situations well. And so for her, she knew that is not going to be where he was going to have success. In fact, it could actually then be detrimental to her to have him as a primary. That is where, again, we talk through these things. We want to make sure that just because you're married doesn't necessarily mean that is the person who should be in those roles. But the inverse is also true. When I got married, my mom had been my healthcare directive representative, but now I did want my husband to be in that position because A, he was going to likely be the person I was with if or when something happened, but also that is now the next step that I was taking, is to have him included. So again, these are all things for every document we talk about. We're going to weigh the pros and cons of who these people should be. The next one that if you are over the age of 18 that you need is a durable power of attorney. This is the document that gives somebody the authority to act on your behalf as far as your finances go. So if you are either temporarily due to surgery or some other procedure or permanently incapacitated, this is the document that lets whoever you have named manage assets on your behalf. Now, one of the things I hear from married people is, well, my spouse is already on the account. Why does it matter? What is this going to do? Well, it does a few things. One, your spouse is not necessarily always going to be available or around. Either they've passed away or maybe they are incapacitated themselves. So we do always make sure that backups are named in these documents. But even if your spouse is around, if you have an account like an IRA, you are the only person as a currently named, able to manage it and use it person. They're not going to be named unless they're named as a beneficiary. But a beneficiary has no right to that money, no access until you have passed away. This durable power of attorney would allow your spouse to access even those accounts and then manage them on your behalf. And so what that does is it allows that money to be utilized if you need it, but you personally cannot get to it. So this is an extremely important document to have for that. The other piece is it allows them to sign legal documents on your behalf. So if you owned a home, let's say, and you guys had been planning to move, the process was already rolling, but no deeds had been signed transferring it over. Or the inverse, you wanted to buy a home, but you, for whatever reason, are no longer in the position to sign legal documents. This would allow your spouse to continue either selling a property or purchasing a new one for the two of you. They can sign on your behalf. So again, this is something to really make sure that you have in place and that it is updated. The other thing, though, is if you already have this document, whether or not the people are going to be changed, you have to have these updated every 3 to 5 years. The reason for that is that banks are really cracking down on financial fraud and more so elder abuse, but fraud of any kind when it comes to finances. So they are not accepting these if they are older than at least 5 years, but sometimes even as restrictive as 3. So if you check the date on your document, if you already have it, or you don't know how to verify if it's current enough, come in and talk to us. So next we hear, okay, so we just got married. I'm going to use a young couple as an example. Okay, fine. You've told me I need the healthcare directive and the power of attorney, but do I need a will? Do I need a trust? Do either of those actually apply to me? The answer is going to be yes. You either need a will or a trust, because that is going to say what happens to any assets you've accumulated, where those are going to go if you pass away. The difference between the two comes down to the next points, though. If you are someone with no real estate, so you don't own any property, or you have an estate less than $184,000, a will at that point is enough to protect you. So if you fall into those two camps, you're just getting started, you guys are just starting your lives, your careers, this is then likely where a lot of our clients are going to fall. But if you do already own property or you have more than that $184,000 figure, then a will is not going to be enough to protect you, and then you are going to need a trust. The reason for that is if you are only under a will with those two parameters that don't then apply, you are going to fall, or your estate is going to fall into probate after you pass away. So even if you are married, there can still be issues where if you never put a spouse on a trust or on a property, if you never put them on your bank account, unfortunately, it can still mean, even though you are married, that we're going to have to go through court to settle your estate after you have passed away. Because if we don't have it designated who is going to inherit from you and take over those assets, the court is going to have to make that determination. Probate is extremely time-consuming and really, really expensive compared to having a plan that would have kept you out of court. Generally speaking, we see probates last from anywhere from 2 to 5 years. That was very impacted by COVID, and so that really is why they're still trying to catch up their calendars, and so people can be kicked down the line a very far way out, which is exhausting for the family and a lot of times emotionally taxing. And then it is also a very expensive process. So let's say you guys set up a will, but you do own a piece of property and now you've passed away. That property would then again have to go to probate, and probate is going to charge a fee on the gross value of that property. So even if you had a tragedy strikes, you just bought the home, you're in a car accident, tragedy has struck. and you only have equity of 200,000 of $1 million home, the court does not care. They're going to put the fee on that entire $1 million value. And so you can imagine how much that can deplete an estate and ultimately prevent, especially if you have minor children, prevent those really needed resources from going to take care of those minor kids. So this is where what I'm really emphasizing right now is that you want to avoid court at all costs. It is not beneficial for anyone involved, least of which, again, would be minor children or kids of any age. So the good news is you can absolutely avoid this. And so again, if you own property or you have more than $184,000, we need you to be set up in a trust. A trust is there to make sure that you, as the creator of it, are going to set the terms of who manages as what we call the successor trustee, if you can no longer manage, and ultimately who is going to benefit from your estate. You get to set all of those terms. And the good news is, in most cases, the court does not have to get involved. I'll tell you the cases where they do in just a second. So the biggest thing, again, is making sure that we avoid the cost and delay of probate. We want to make sure that all of our clients, everybody that we talk to, whether you end up working with us or not, that you know there are ways to avoid probate and dealing with that. But trusts also allow for a lot of advanced planning. And one of the things that we're also going to talk about today is especially for people with children who maybe have blended families and have beneficiaries they really want to make sure are protected beyond just they get the money. There are a lot of options and opportunities for you within your trust. But one of the downsides, and this is where I said in most cases a trust avoids court, the only ones that don't are the people that do not properly fund their trust. So what this means is after you've set up a trust, there are certain assets that actually become titled in your trust name. Now, the good news is with a revocable trust, it's under your social security number and it's you who gets to manage it. So taxes don't change, access and control doesn't change. Things really from a day-to-day don't change. But those assets that need to be in the trust name to make sure that they will not go through court are your pieces of property, your checking, savings, and non-retirement investment accounts. Those things need to go into a trust name. That way, again, they do not avoid probate. Because this is such a vital step, my biggest recommendation is if you already have a trust and you do not know if you have properly done this or if your attorney that you worked with had properly done this, make sure to come in and talk to us. For our clients, we take care of recording their California property deeds and assisting them with out-of-state deeds. So that piece, if you've worked with us, that has been accomplished, unless you have refinanced. So I'm going a little bit off the newlywed piece or the married component for just a second, because if you had put your property in the trust through us, but you have refinanced since, there is a very good chance it is no longer protected. All of this is to say, if you have questions on assets and whether it has been done correctly or not, again, come in and talk to us. We are happy to have that conversation with you. Now, one of the other documents that we set up is what we call a pour-over will. So yes, we encourage you strongly to make sure that those assets are properly in the trust to avoid probate. But if something has happened where you either forget what we've talked about, or you've made a choice for whatever the reason to not put assets in the trust, this pour-over will is there to essentially capture those assets after you have passed away and put them back in your trust. Now, the problem is we do still have to go to court to ask them to make sure that that can be done, but it keeps the asset from going through the full probate and ultimately then means that the asset will go where you have dictated or decided rather than where the court is going to decide. So we do create this safety net because, again, we understand that things happen. And then one of the other pieces that we focus on is not just your assets, but it can be the more emotional side, and that is generally speaking people's stuff. The stuff is a lot of times where we actually see some of our worst fights. And so with your things, it's really important to make sure that you know where they're going and that they're going to the appropriate people. So just because you're married doesn't necessarily mean that you don't want some of your things to go to other people. So for newlyweds, things like that, you got some gifts. And some of the times those gifts are going to be, they could be heirlooms that have been passed down. It can have family meaning that was gifted to you as a result of your marriage. But there's some importance of keeping in the direct family bloodline rather than it necessarily going to your spouse. Or it might be that you want it to go to a specific child that the two of you have, rather than your joint kids having to figure out who gets what. All of this is to say, when it comes to your stuff, we have created a provision within your trust that says if you have things you want to specifically designate to specific people, all you need to do is put in your handwriting what the item is, who it goes to, and sign and date it. You don't need a witness or a notary, and this allows you to designate items to whomever you want, whenever you want. So if you change your mind, you can simply tear the letter up, and if you want to create a new one, you get to do it on your own time and for free. So that's always a plus. But this can really help take out some of the fighting that we see after somebody passes. But again, especially if you were given something, even as a wedding gift, but that it is important to keep in your direct family, you're able to then do that as well. Now let's talk about, okay, you're married, but you also now have children, or you had children coming into that marriage. So one of the big things is, and it sounds silly, I know, but when it comes to children, you can give them the gift of planning, whether that's helping them plan for themselves or setting up your plan so that they don't have to guess at what you would have wanted, and really that they are able to stay out of court. One of the things that we'll say, and it sounds silly, but it's true, is nobody plans to fail, they just fail to plan. Most people want to make sure that things will go smoothly after they pass. And one of the best ways to make sure that happens is to make sure you have an up-to-date estate plan that properly accounts for your wishes and the legacy that you are looking to leave. So one of the big things is you just got married. Now I'm going to use myself as an example again. Before I got married, I had my IRA that would go to my mom if I were to pass away, because she was the most appropriate person, because I knew she would likely be the one dealing with the aftermath of me passing. But as soon as I got married, I wanted to make sure that that would be my husband. And so one of the big things is that if you had beneficiary accounts prior to being married, if you want your spouse to now go on those accounts as your primary beneficiary, you have to actually designate them appropriately and accordingly. So generally, this is then working directly with the banking institution or financial institution to make sure that that is accomplished. There is no automatic beneficiary. So if you have not designated it appropriately, whoever is named is who will inherit. So again, if you want it to be your spouse, you have to make sure that they actually get named on those accounts. The other piece, though, is, do you have minor children? This could be you have minor kids together, or you each brought in minor children. When we're looking at minors, this is often one of the hardest, frankly, points for our clients and parents to talk about. The reason is there's almost no scenario in which you want to imagine that you are not going to be directly involved, especially when it comes to things like how the child is raised and emotions and religion and where they go to school. Those are very intimate decisions. So again, we completely understand this can be really hard for parents to even want to think about the planning, let alone to come in and do it. But your minor kids are obviously extremely important to make sure that they are protected in the horrible event that you passed before they were 18. So this is where we start talking about guardians. Who should those guardians be if you were to both pass away? When we're looking at this, we look at, frankly, their personality of the guardian. Is it going to be somebody that is similar enough to you in values, beliefs, in just their day-to-day personality that you trust they would raise your kids at least close to how you would want them to be raised? Are they financially savvy? You do, again, want to make sure for your own children that whoever they're going to, that the person can at least do basic money management so that your kids are not going to be wanting for much outside of, obviously, you. But then there's other components that go into that. And so when we're talking again with our parents and our clients, these are some of the things that we want to make sure are considered. I did get one question, so let me go back really quickly. So for separate property, does a pay on death eliminate probate? So pay on deaths and transfer on deaths, when you have beneficiaries, they do generally, yes, eliminate the deed for probate. So they can be a really good, at least temporary solution. One of the only issues with doing just pure beneficiary designations rather than having a trust is that if, God forbid, your beneficiary passed away also, then that asset is going back into probate. With our trust, we do a lot more of contingency planning. And so we have, if this person passes, it's going here. If that person passes, it'll go down the line. So that's one of the only things to be cautious of. All right. Then jumping a little further, one of the other pieces with minors is just because they are now an 18-year-old doesn't necessarily mean they are mature enough to actually manage their inheritance, especially if they're going to inherit more than a couple $1,000s. A lot of 18-year-olds, as much as we can love them, don't have the maturity to inherit a lot of money. So one of the things that we're able to do within your trust as well is create what we call minors trust provisions. And these can actually then continue after your child turns 18. So it might mean that they no longer have a guardian, but you can then designate when they would get the money, and if you wanted in increments, what those are going to look like. So that allows you to maintain a little bit of that control and ensure that the money is going to be used at least more appropriately than them potentially receiving it all at one time. So that is, again, something that your trust is able to provide for you that any kind of other planning just is not going to be able to. Now, for those of you who have adult children, there's also significant protection available for them as well. So let's say that your adult children are actually the ones who just got married. So you've been married, or you're not married, but you have kids who now they're going through that newlywed phase. And hopefully you like your new son or daughter-in-law, but you don't always like them, for one, as horrible as that may sound. But you also wouldn't necessarily want them to get the inheritance you want left for your child if your child was no longer living. So one of the things, or in a different case, that they got divorced. So one of the biggest things that a lot of parents then are looking to do for their adult children is to put in what we call protective lifetime trust provisions. What that means is that if your child is married and then got a divorce, their inheritance cannot be taken away from them in a divorce proceeding, not even in a community property state like California. It also protects it from lawsuits, creditors, bankruptcy, and the IRS. But one of the biggest concerns is, again, what if my child gets divorced? I don't want their now ex-spouse to have any access to that money. The other thing is, what if your child passes away? I talked to a client just last week who was saying, well, if my child passed, I love their spouse. I would want him to receive it. And I said, that's great, not to throw a monkey wrench in the system, but what happens if she passes away and he remarries? Do you want that inheritance now to go to a new family that you likely will never meet? Because again, well, actually, you will never meet because you have to pass away for these provisions to come into place. And that made her pause and go, I really like him, but yes, would I actually want the money to go to a new family I've never met? The answer to that is no, especially if they have grandchildren. And so this can prevent even that sort of situation from occurring and actually ensure that your grandkids would receive it rather than, again, a new family that you may never, ever get to meet. All right. Then we look at other beneficiaries. So just because you have kids doesn't necessarily mean that they're the only ones you want to inherit. And actually, in some cases, people do want to skip right down to the next generation or to give it to charity or other places. All of this is to say that your trust is able, again, to be customized and planned for according to what your wishes are going to look like and be. And then actually one of my favorite topics, but often can be one of the more complicated, are our blended families. A lot of times with blended families, the complication here is it's typically later in life for people who have just gotten married. And so there's asset considerations. The kids may be all grown and never grew up together and haven't really had a chance to get to know the new spouse. They might be minors, and so things are going to be more blended. This can, though, again, be a more complicated topic. Again, though, the great news is with your estate plan, you are able to designate where you want things to go, how they're going to be divided, and you can add protection around each of the beneficiaries individually. So there is a lot that we can do in your estate plan to make sure that everything is planned for accordingly. All right, and then you just got married. We want to focus on the positives. We want to make sure or focus on you'll never get divorced, but we understand that things can happen. But we also understand that even if your marriage is lifelong, it exists until the day you pass away, it doesn't necessarily mean that if your spouse remarried, you would want them to take the entire estate into a new marriage. So one of the things that we do talk to our married couples about is what happens if you pass away? Do you want your spouse to be able to take the entire estate and potentially use it for a new family? A lot of times the answer to that question is no, especially if it is a younger couple where if they were to pass away soon, the odds are remarriage is extremely high. So with that being said, we then talk to them about what are called AB trusts. An AB trust essentially says when one of the spouses passes, the trust is going to split into two parts. The survivor can still use the money for their benefit from both sides of the trust, but they could not change the terms of the decedent's portion. So what that means is whoever the person who passed away said that would inherit from them, that has to stay in effect. So if your spouse remarries, they cannot write in a new wife or husband to your portion of the estate, and they cannot cut out any of the beneficiaries that you have wanted included. So it ensures that that half at a minimum is going to ultimately go where you would want it to, not for whatever life is taken for the spouse who has survived. If you have any questions on that protection or what that entails, come and talk to us. Now, as a new married couple, again, you also have some tax benefits. One of the biggest components is you can gift money to each other as much as you want. So paying for things for your spouse and doing that sort of thing, you're not getting taxed on it at this point. But there's a lot to be said about taxes. I'm really not going to dive too much into this because this can be a very, very case-by-case situation. But if you have any question on how to maximize benefit or tax benefits as a married couple, or what that's going to look like after you or both of you have passed away, come and talk to us because this is a drier topic, but actually one of the most exciting and influential topics for people that you might not even realize. Again, one of the biggest is the gift tax component. So this is something that if you are interested in gifting, either just because you want to, or because you are concerned about after death taxes and how do you make sure those don't apply, this is something to definitely come in and talk to us about. With gift taxes, one of the big changes is that now you can actually gift up to $17,000 per person. So if you're married, that means you and your spouse can each gift every person you'd want to $17,000 per year without ever telling the IRS you have done that. So this can especially be important for, we've noticed, with grandparents wanting to help grandkids with education. This is a great way now for them to be able to do it. But there's also what's called a lifetime exemption when it comes to your gift taxes. So what that means is unless you're going to be gifting over just shy of $13 million, you actually wouldn't pay any sort of gift tax at this point. If you have any questions on that, please again, come and speak with us. Now, one of the other big taxes that, again, applies to everybody is going to be the federal estate tax. Now, some people are able to avoid this because the size of their estate does not hit the threshold for the tax. However, the federal estate tax is a moving number. So right now, it's just shy of 13 million. What that means is if you passed away and your estate is 2 million, there's no federal estate tax. But that number is going to reduce in just only about 2-3 years to between 5.5 and 6 million. So now if your estate is $6 million, you're going to have an issue if you passed away after the exemption has been reduced. So this is where I say, as much as I know nobody enjoys talking taxes, at least most people don't, and dealing with them, it's a really important topic to make sure you at least discuss with your attorney and make sure that you speak with an attorney who knows to bring these things up, because it can have a profound impact, not only on you directly if you're inheriting, but also on anyone inheriting from you. So one of the big things that we also focus on is how to leave a lasting legacy. Legacy is extremely important at Koppenbarger, and the reason that we were actually founded by Lloyd Koppenbarger is because he truly believes everybody has a legacy and that legacy matters. And so when we're talking about you just starting out as a married couple, or you've been married for decades, we want to make sure that your estate plan is going to properly protect, provide, and assist with the legacy that you are wanting to leave. Now, for some people, that legacy is going to focus on finances. And so your estate plan can absolutely ensure that your finances and that financial legacy you want to leave is going to be maximized and go ultimately where you want it to. So the financial piece, we can 100% make sure that you are taken care of from that standpoint. But for a lot of people, they also want to deal with an emotional legacy. They want to leave that emotional legacy because that a lot of times can actually have a more lasting impact even than the financial. So if you have any questions on how to leave an emotional legacy or what that's going to look like, absolutely come and talk to us. A lot of times these are the questions that from a cost standpoint cost you nothing, because we're just talking to you about, again, emotion. But it is something that we are very passionate about and want to make sure that when we're looking at our clients, we really are looking at a full comprehensive view that includes this side of things. So again, we've gone through quite a bit. So what I really want to make sure that you take away is that if you are over 18, whether you're married currently or you've been married you're a newlywed or you've been married for decades, you at a minimum want to make sure you have a healthcare directive and an up-to-date financial power of attorney. But planning also changes. So if you had already done planning and now you've been married since you had originally done it, we want to make sure that that then properly accounts for that new spouse and new family that you have. But ultimately, everything that we focus on is making sure that you plan when you can to avoid any unnecessary legal situations like probate. So as I had mentioned, we have been around for 44 years. And so what that means is that we are really able to do a deep dive with our clients who need it or want it to make sure that they are going to be properly protected, no matter how complex and complicated that situation may be. Every single person has some sort of estate planning needs, and our firm is, again, with our customized estate plans, able to meet those for our clients and the people who work with us. We also are very big on continuing not only our education, but continuing our clients' education. So we do these webinars numerous times throughout the year, often as much as even twice a month, but we also do client seminars. What that means is once you become a client, you may not need to know as much of the preliminary information, but we want to make sure that you are kept up to date on the law and what's going on. Education is one of the biggest things that we do focus on. And so that can be a huge value that we provide to our clients that often is not provided for by other attorneys or firms. So that is a huge piece of working with us, that we stay in contact with you and we make sure you know what's going to apply and what is going to be important to ensuring you continue being protected and that legacy really is going to be met. After this, you are going to receive an automated phone call from us asking if you are interested in setting up an appointment. As I mentioned, for all of you attending today, that appointment would be complimentary. So it won't cost you anything to come in and meet with us, and then we can walk you through what are your current needs, what are your questions, and how can those be best addressed. And we're able to then, if you need planning or changes, we're able at that point to give you a cost so you know exactly what it would be if you wanted to move forward with work. But ultimately, we are here to help. Thank you for taking the time to sit and watch this today. I hope it was helpful. If it led to more questions and more specific questions, again, we are absolutely happy to answer those. I'm going to hang out for just a couple more minutes to see if there's any questions that come in, but I hope you all have a great rest of your day and a wonderful week. All right, it doesn't look like we have any questions coming in, so thank you all again, and we look forward to speaking with you.